And we do have some breaking news. That injunction temporarily blocking Florida's 15-week abortion ban has now officially gone into effect.
But moments ago, the state of Florida filed an appeal. Local 10 News reporter Christina Vasquez joins us live this midday with what all of this means. Christina.
And that means all of this happening very swiftly, that as soon as Judge John Cooper out of Leon County filed that written order, as you said, that statewide temporary injunction on HB 5, Florida's new 15-week abortion ban that took effect on Friday, that went into effect. And then the second the state filed its appeal because of Florida's appellate review procedures, the second they filed that appeal, that means that injunction is already on hold. New this morning, take a look. Leon County Circuit Judge John Cooper's signed written order blocking Florida's abortion ban, which took effect Friday, is filed with the court, making, in his words, the statewide temporary injunction he granted binding. On Thursday, he said from the bench Florida's new 15-week abortion ban is unconstitutional and that it violates the privacy provision of the Florida Constitution. In his order, Judge Cooper explains how the Florida Supreme Court has, quote, determined that this right to privacy is clearly implicated in a woman's decision of whether or not to continue her pregnancy. Several providers, to include Planned Parenthood, sued the state, arguing HB 5, quote, will unlawfully intrude upon the fundamental privacy rights of Florida women. In the state defendants' response, they argued providers didn't have standing because plaintiffs' constitutional rights are not at issue in this case. Only their patients' rights are. Signed into law last April, HB 5 restricts abortions after 15 weeks. Previously, it was 24. Does not include exceptions for rape, incest, and human trafficking, and was modeled after Mississippi's, which was at the center of the Supreme Court ruling, a ruling that has placed state constitutions in the legal tussle and spotlight on abortion rights. Judge Cooper adds that he believes his written order is not affected by the recent Supreme Court decision ending 50 years of federal abortion rights because the right to privacy under the Florida Constitution is broader, he says, in scope than any private right under the United States Constitution.
The major difference between the U.S. Constitution and the Florida Constitution is the U.S. Constitution does not have an explicit right to privacy within it.
Law professor Carolyn Mala-Corbin, a constitutional scholar with an expertise in reproductive rights, explains.
Moreover, the Florida Supreme Court has held more than once that the right to privacy in the Florida Constitution extends to protection for abortion.
And we knew that that was likely going to be what was decided in that case.
As his executive office told us, the next legal battle will be to appeal and ask Florida Supreme Court to reverse precedent on the issue, adding, quote, the struggle for life is not over. And once again, to recap, a very fast-moving morning. So essentially, again, that statewide temporary injunction that Judge John Cooper out of Leon County granted and that went into effect when he filed that written order with the court was probably in effect, at my estimation, by less than an hour, because as soon as the state appeals, according to, again, our appellate review procedures here in the state of Florida, it means that injunction is already on hold. The next legal step would be that attorneys representing plaintiffs in this case, the plaintiffs being providers like Planned Parenthood, their attorneys, the ACLU, they could now decide to file a motion with the lower courts trying to lift that automatic stay. Certainly, stay tuned. Reporting live for you, I'm Christina Vasquez, Local 10 News.
Christina, thank you.